My name is Paul Kaindo. I'm a senior legal counsel at the Kenya Copyright Board. I want to talk about the Amendment Act as far as Section 46 is concerned, that is in relation to collective management organizations. So the changes or the amendments that were brought in affecting the collective management organizations are many. Particularly when you look at the Section 346 3A, which is a new addition, it provides for instances when the Kenya Copyright Board, the regulator, can issue a provisional license. That is a temporary license. This temporary license or provisional license cannot go beyond 6 months. After 6 months, the board has to make a decision whether to grant an annual license or to give or not to grant the license. Now, some of the instances under which a provisional license may be granted to the CMO is, for example, where the CMO has not submitted a complete application and there are genuine reasons as to why that has not been done. So in that instance, instead of leaving a lacuna where the royalties are not being collected, the board, the regulator can decide to issue a provisional license. Another instance is where there is administrative shortfalls, where administrative shortfalls are apparent and there are good reasons again for that, then the board may issue a temporary or a provisional license. And like I said, that cannot exceed 6 months. The second amendment touching on the CMO relates to the procedure of deregistration. The previous act did not provide for a procedure. It simply said that if a CMO does not comply with the conditions of the board, they can decide to deregister, but do not provide for the procedure. Now the new amendments provide for a clear procedure, and KECOBO may deregister a CMO if in the opinion of KECOBO, the failure of the CMO is prejudicial to its members. Remember, these CMOs exist for the best interest of the members, but if that objective is not being met, then the board may decide to take away the license. Before taking away the license or before the registration, there is a requirement that KECOBO must notify the CMO in writing and require the CMO to make a presentation or a representation explaining why it should not be deregistered. The CMO should actually respond days. And that should can either be done by the CMO or any member of the CMO can actually decide to make a representation against the deregistration. Now, the board, other than deregistering, may decide to sanction the board of directors as opposed to simply deregistering them. So the idea was to ensure that this collective management of copyright continues without disruption. The third very important amendment in the Act provides for the qualifications and tenure of directors and chairperson as well as the CEO of the collective management organization. There is a requirement that the directors and the chairperson of the CMO must at least have a post-secondary school qualification. So he ought to have either a certificate or a diploma as long as it is beyond secondary qualifications. Now, the director and the chair hold that office for a maximum period of 3 years, which is renewable once. So they run for 3 years. Then if they are re-elected, they run for another 3 years. After that, they cannot run again subsequently. Now, the CEO of the CMO holds the office for a period of 4 years, and that is renewable once, subject to satisfactory performance as evaluated by the directors. So before the term of the CEO is renewed, there must be an evaluation that has been done by the board of directors, and the renewal should be based on that performance. The third, I think the fourth amendment relates to inspection and control of the CMOs. Now, KECOBO may authorize any person to inspect the books of accounts and records of the CMO. So any person can request the board, the Kenya Copyright Board, to do an inspection, and the Kenya Copyright Board can appoint any person to do that inspection. And when that inspector is conducting his duties, every staff or employee of the CMO is under an obligation to comply with the directives of the inspector. So if the inspector asks for any information, the staff or the employee is under an obligation to provide that. If they don't do so, then they commit an offense, and that is punishable with a fine of up to 200,000 or imprisonment of up to 3 months. Now, once the inspector has conducted the inspection, and remember, this inspection is not an audit. It is an inspection, and it is this inspection that can inform the need for an audit. So the inspector reports on any breach or non-compliance or non-observance of the requirements under the Act or regulations or any conditions that has been set by the regulator, in this case KECOBO. So if he realizes there is that non-observance, then that is, he makes a report based on that. Then if he notices any irregularity in the manner of conduct of the business of the organization, then he needs to also report that. He also reports on any apparent mismanagement or lack of management skills. So if he realizes that there is a lack of management expertise, then he needs to report that to the board. And any other matter that may require a forensic audit should also be reported by the inspector if he notices the necessity of the same. Now, once that report is done by the inspector, then the report is given to the CMO. Then KECOBO writes or submits a report to the CMO. The report is based on the report of the inspector, and then again the CMO is given an opportunity to be heard and to defend itself. And KECOBO may decide that instead of deregistering, it sets conditions which the CMO is supposed to follow. Now, there are some. What can the board do when it realizes when it receives the report? It may either recommend the suspension of or removal of any staff or any employee of the CMO. It may issue directions regarding measures to be taken. It may also require the organization to reconstitute its board of directors. It may also demand a plan to resolve all the inefficiencies that has been noticed as a result of the inspection. It may also appoint a person who is suitably qualified and competent to advise and assist the CMO in complying with the directions and conditions of the board. In extreme measures or in extreme circumstances, the board may either give an order for the revocation of the license, or it may issue an order placing the organization under statutory management. But note that these are in extreme measures. So this act gives options other than deregistering the organization. It gives options of resolving issues that may actually be in the CMO. Now, the fourth amendment relates to record keeping and attendance of meetings by the board representative. Now, the directors of the CMO are under an obligation to keep, update, and maintain a record of minutes and resolutions of meetings. So that is a requirement. And again, the board, the Kenya Copyright Board, may attend and advise meetings of directors of a CMO where matters affecting members' interests are being proposed for discussion. Now, what are the benefits that come with this amendment as far as CMOs are concerned? One, it ensures that there is transparency, accountability, and good governance in collective management organization to ensure that the right holders get their dues, to ensure that once the board, the regulator, sets the conditions. For example, it says that 70% of the collection must go to the right holders and 30% is what is used for administrative purposes, then that must be complied. The Act makes it possible for the board to take action where that is not followed. So eventually, of course, once it is complied with, it means that more money will get into the pockets of the right holders, and of course, the 30% administrative cost is put into good use. Now, something I need to mention before I close is that the Act requires that a system be developed to ensure that these rights are digitally managed. Now, regulations have been developed. These will ensure that there is a system that provides for a digital registry as well as royalty collection and distribution system. So that will ensure that it's very easy for that. So there will be a digital platform. So under that digital platform, right holders or the artists will be required to upload their work in that particular platform, and of course that will make it easy for the right holder as well as the regulator at the CMOs to monitor that work, so they can tell that artist X's work or music has been played by a broadcaster X. It has been played for this number of minutes, and therefore this is what is due to the artist. So we are going to see the scientific distribution of royalties becoming easy, and it will be verifiable under the system. So with the help of those particular amendments, it will be very easy to ensure that the artists actually get their rightful dues. Thank you so very much.